Hey everyone, Terry here. Welcome back to Simply Legal. Today we are here to host a very important guest on the channel. This is our second Zoom edition on Simply Legal. And normally I host big lawyers in the field, both in Uganda and across the globe. So today I'm here to introduce to you Madame Ddungu Frances. I met her through a friend and an hobby of mine I was with in King's College, Budo. I did an earlier video with him. It's called Katumpanga. So he recommended Madame Frances for me, and I'm so excited to have her on the channel. And maybe she can introduce herself. Madame Frances, how are you? Welcome to Simply Legal.
Thank you so much, Sarah. You've already introduced me. I don't know what else to say. But yes, I am Frances Ddungu Smith. I am a lawyer trained in Uganda and also in the United Kingdom. I'm a High Court advocate in Uganda, and I am also an advocate in the United Kingdom. And at the same time, I am an arbitration practitioner and also a mediation practitioner.
By the way, I read your profile, and I saw that you are part of the Arbitration Association. Is it the African Arbitration Association, the AAA? Then I know that you also have 10 years experience in being an advocate both in Uganda and in the UK. And I was really impressed by your profile. I know that you are someone who is an expert in the field of arbitration. So we are talking a lot about arbitration, but the viewers want to know, Madame Frances, what is arbitration in simple terms? Because here at Simply Legal, we aim to simplify the law for people. So what is arbitration?
Arbitration, in simple terms, is a type of alternative dispute resolution. This is alternative, meaning alternative to going to court. The traditional way, for instance, if people have got a dispute, usually they go to court to resolve their disputes, no matter whatever it is. But arbitration is the alternative. Instead of going to court, parties choose an arbitrator, or an arbitrator is appointed by an institution, whichever they have agreed to resolve their dispute. And whatever decision the arbitrator makes or the arbitration tribunal makes, it is binding and legally enforced in law. So it is as good as going to court and getting judgment.
Yes.
So that is arbitration in simple terms. Yes. Okay.
So personally, I have come across arbitration when I was back in law school. I was in Uganda Christian University, and I actually handled arbitration. I actually have a certificate in arbitration. I think it was CADA, that's Center for Arbitration and Disputes Resolution. So they came to our university and they taught us about arbitration, and they even they came up with simulations for which people would now go through mediation sessions and arbitration. And actually this was basically alternative dispute resolution. However, the viewers may also want to get a grasp of what alternative dispute resolution is and its types briefly before we dive into arbitration and mediation.
Alternative dispute resolution, just as the word is, I usually say to people, the answer is usually in the title itself. It's alternative dispute resolution. You know, if you have a dispute and you want to resolve it, what alternative way is there instead of going to court? So that is alternative dispute resolution. So instead of going to court to resolve a dispute, it might be a commercial dispute, it might be a land dispute, something, a conflict whereby you need somebody like a judge to settle it. what other way can you use? So that is all in general, that is alternative dispute resolution. So instead of going to court, you can decide to use mediation, to go for a mediator to mediate so that you can resolve your dispute. You can use negotiation. You can use parties in commercial world. Sometimes they can use expert determination. This is where you get an expert. Both parties, it might be in a complex area like oil and gas, and you're the person who can determine whether there was a leakage of oil and something. It's got to be that specific person who is who has got expertise in that area. So other than deciding to take the matter to court, probably the judge who might be sitting on the case doesn't have that specific expertise in, so they decide that for us, when we are going to resolve our dispute, we're going to use an expert determination. And whatever decision the expert makes, it is binding and is enforced in law. So those are all types. It could be negotiation, expert determination, mediation, arbitration. All of these are classified as alternative dispute resolution.
Wow. You've really explained to us properly exactly what alternative dispute resolution is. I read a bit of your profile and I came across the fact that you did a master's, which is LLM in oil and gas, right? So, and you also mentioned something concerning you dealing with maybe leakages in oil pipelines. So have you conducted any mediation or arbitration sessions in terms of oil and gas?
I have conducted arbitration and mediation. First of all, these are two different things. Arbitration, I've already explained what arbitration is. Mediation is whereby parties decide to choose, again, somebody to mediate on their behalf to resolve their disputes. And the decision which a mediator makes is not like legally binding, but people come together to see if they can resolve their issues. That is mediation process. These are two different. If the one for the arbitration, the arbitrator's decision is binding. We call it an award. When makes an award, that is legally binding and it's enforceable. So it's different. They are both alternative means, but they are really different. If you look at the mediation or an arbitration process, how everything is run, they are absolutely different. In the mediation, there is no calling of witnesses and all of that. And whereas in arbitration, you have it is similar to the court, but it's different in a way. It is kind of like it is party-led. So that is the difference. Yes, I've conducted cases in oil and gas and in the UK. Yes, I have through arbitration. Yes. Okay.
So another thing I've been trying to understand is the process of arbitration handled here in Uganda different from the way it's handled in the UK? Because I believe we got our common law from the UK. So I'm just curious. I know you've handled arbitration sessions here, both in Uganda and in the UK. So what is the difference between them?
First of all, arbitration, people must have an arbitration agreement before they go to arbitrate for arbitration. You can't simply wake up and say, oh, well, now I've decided I just want to go for arbitration. You need to have, parties need to have an arbitration agreement. And the arbitration agreements, in Uganda, we have the Arbitration and Consideration Act 2000. That's the one which governs how arbitration is going to run, how arbitrators are going to be appointed, basically it just tells you everything about arbitration. For those people who are interested in knowing how arbitration is run in Uganda, read that act. That is how arbitration is being done in Uganda. Obviously, on a session like this, it's very difficult to take you through the whole thing. In the UK, we have the Arbitration Act 1996. they're very similar, I have to say, very, very similar, but they're different in certain ways. But not, the process is not very different, I have to be honest with you. If you read the two acts, you might be thinking, you're reading the similar, is the same thing. But it's different because, for instance, in Uganda, there is the ancestral model law, which they are using, and the 1985, which and the UK have also adopted another one, the 2000 and the arbitration rules for the 2006, which Uganda has not changed. So if there are certain things which they have added on, and Uganda has not added on that one into their legislation, so you find out that certain things can be done in the UK, but they cannot be done in Uganda because they have not ratified that UN, the ancestral model law, which is being used. So, but the previous one was incorporated into the Uganda law 100%, and hence the act which we have of the current act. The current act, but the new amendments of the 2006, over the ancestral arbitration rules, has not been changed into have not been adapted. So when you're doing arbitration, you need to understand which country has adopted both the ancestral model laws and which hasn't done it. Uganda has not done both. So the law reflects on what level they have done. So these are, when I talk about the ancestral models, these are the international laws, which basically they have adapted into the local legislation and ratify them and say, we're going to run it by this way. But they've got a lot of similarities. Yes. Okay,
so who is an arbitrator and how is an arbitrator chosen in arbitration sessions? Because personally, I did my clerkship after my Law Development Center studies. I did my clerkship at the Commercial Court of Uganda in Nakasero, and I attended about 5 arbitration sessions. But it was really interesting the way a lawyer or anyone who has legal expertise in the field can be chosen as an arbitrator. But I've never really known the process of who an arbitrator is or how they are chosen, that kind of thing. So maybe the viewers may also want to know, how is an arbitrator pointed out, or how is an arbitrator chosen in these arbitration sessions?
That's a very good question. An arbitrator is call them an umpire, or in a football match, call them like a referee, or call that person as a judge. But they're not judges, they're arbitrators. So this person is appointed, or sometimes it's a panel of the 3. They're appointed by the parties themselves. And that is the beauty about the arbitration. You see, when parties go and say, we're going to be resolving our disputes, in their contract, they say we're going to resolve our disputes by way of arbitration. They decide, they can say that we are going to they choose an arbitrator. It's like you yourself having a case and say, I'm going to choose my own judge. You see what I mean? So they appoint arbitrators themselves. So arbitrator is an umpire or a judge or somebody who is going to resolve a dispute. It's just that whatever decision that person makes in a particular case, all parties have got to understand that it's going to be legally binding and it is enforceable in law. So you succumb that this person we have chosen, if a decision has been rendered, that is enforceable in law. So this is an arbitrator. Usual arbitrators, you can find out that many arbitrators have ended up becoming being retired judges because of their experience in dealing with cases. But that does not mean that a person who is not a judge or from legal experience cannot become an arbitrator. You can become an arbitrator as long as you have the relevant experience and you have done the training. You can become an arbitrator. You don't have to have a legal qualification, or you don't have to be a judge or a retired judge. So parties choose in arbitration, and that is the beauty. Parties decide. There's a lot of what we call party autonomy. Parties decide who their judge is going to be, or who the arbitrator is going to be. So usually each party can, like, there is a panel, they can decide to have a panel of 3 arbitrators, or to decide on a certain case. Like in commercial cases, usually there are 3. So you find out that one party will say this is going to be the arbitrator who I'm going to appoint, and then you, Terry, if you're against me, you also choose yours. Now these two arbitrators who we have chosen, they choose another one jointly, who is like an umpire, as a chair for the arbitrators. So they are usually 3, because in case they don't agree, the majority obviously will be the ones who decide that this is how the case should be. So they are usually 3. In Uganda, some people decide there is what we call ad hoc arbitration, and the one which is also institution-led. Ad hoc arbitration, this is whereby parties decide to do it without using an institution to run the arbitration, like CADA, you've just mentioned about the Center for Dispute Resolution in Uganda, Dispute Resolution Center in Uganda. So usually CADA, the way it can, for people who say, we want to do arbitration, but we want to use CADA. So CADA has got a list of arbitrators, will be the one to use like to do the administration of even saying, we recommend this is the arbitrators to use, then they can appoint them and all that kind of stuff. But that doesn't mean people who decide to use ad hoc arbitration cannot do arbitration themselves without using a center. But in Uganda, yes, we do have CADA, we have ICAMEC. So the institution runs, they do the administration of it, and including appointing arbitrators, including if the parties are not happy with that particular arbitrator, then they can do all the administration about it.
Okay. Wow, that was really detailed. They also want some of the viewers of Simply Legal are both lawyers and they're both lay people. So they also want you maybe to give them an overview of the Arbitration and Conciliation Act of both Uganda and also the one in the UK. You could just give us a brief look at both of those acts and maybe just help people understand.
I think that is a very generic question to ask, because it's like getting a whole legislation and say, can you give us what it means and what it's all about? It's very generic, and I can't give an overview of that. However, what I can say in brief, in brief, I can say that the Act gives you an example of how a form of an arbitration agreement, like for instance in Uganda, the Arbitration and Conciliation Act, it is very clear that it must be in writing. By the way, it must be in writing before people go to arbitration. And in fact, if parties decide that they're going to settle their disputes by arbitration, it says you cannot now say, now I don't want to go for arbitration, I've changed my mind, I take my case to court. The Act is very clear that once you choose that you resolve your disputes by arbitration, you cannot go to court and file a civil matter. The judge will refer you back to arbitration so that you resolve your dispute through arbitration. It also gives, the Act in Uganda gives, which is also similar in Uganda, it says what happens when a party dies. For instance, you make a commercial agreement, as you can see sometimes when you do an agreement and one party dies, then like that is the end of the matter sometimes, because the deceased has already gone. But in arbitration, which is very good for people who want to be very secure, that even if you die and you have signed an agreement, whoever your estate, those people who come in your position, that agreement will be enforced against them. So there is that survival of that. They will sue whoever remains. So that is a very important thing to aspect to really concentrate on about, because people do agreements and maybe somebody has sold land to somebody and somebody has died, and it's like, what is going on? Whoever the agreement doesn't die off, it just continues, and that also it runs in both in the UK law and in the Ugandan law at the same time. Also, in Uganda, the act, both acts, the one in the UK and Uganda, I told you they are very, very similar. They talk about the number of arbitrators, what the rights of the arbitrators, the process to use, how the grounds of challenging the decision. For instance, if the arbitrators makes a decision, how can you challenge it? How can you appeal? Because there are very limited grounds on which you can appeal. An arbitral award is very, very limited and very slim. So it actually,
I think it's very difficult.
It is very difficult because they've limited the grounds, and even both in the Ugandan Act and the UK Act, it is still similar. So if you read this act, it will actually show you how the whole thing absolutely ran. And then it also talks about the place of arbitration, or because parties decide where you can end up having a contract between you and China, a Chinese company, and you're in Uganda. So where is the arbitration going to take place? Are we going to use the Chinese law? Are you going to use the Ugandan law? What is going to happen? What language is going to be?
That's a very good question. I think you've actually led us to something personally, even me, I would want to know. How is that done? If you're chairing an arbitration session between countries, especially when it comes to oil deals or international trade, how is it done? Maybe you could just simplify it for us briefly.
Usually what happens is parties, before they even go for arbitration, when they are drafting, you as a lawyer, when you're drafting an arbitration agreement or an arbitration clause, it doesn't have to be a 20 pages agreement. A clause can just be a paragraph. You need to decide, let parties have got to decide what is going to be the law which is going to be applicable. For instance, if it is a Chinese company dealing with a Ugandan company, what law are they going to use? What language are they going to use? The parties choose that. And also they can choose. So it is that which as an arbitrator you're going to use. But you're going to find out in a situation whereby they have not. Terry, can you still hear me?
Okay. So yes, I was asking you earlier that what is the process of what's arbitration process? In fact, I think we should first ask for what is the arbitration process generally, and then we also go to the arbitration process between countries, because personally I'm curious. I'm a very huge fan of international law, and I like to read up on how countries do dealings, but I've never exactly known how countries can do arbitration or mediation sessions. But now, since we're still tackling arbitration, we should now give an instance of, let's say, Uganda and Russia, or Uganda and China. Maybe you could give us an overview of how an arbitration process is done between two countries.
That's a very good question, Terry, because at the moment, we see a lot of dealings between international companies. You find out that you've got a country which is, let's say, UK, has got Tullow Oil and is coming to Uganda to do business with Uganda. You see Sinop in terms of oil trying to do business in Uganda. You see Tanzania, who are trying to build up this tunnel for the pipeline to deal with Uganda itself. You see Kenya. So at the moment, we have absolutely opened up borders, and there is a lot. It doesn't have to be Russia, it's even Kenya. Any business dealing which you're dealing with somebody who is not a native of your country is an international aspect. Even now at the moment, we have the Africa Free International Trade Agreement, which has been signed, which has absolutely opened up businesses. That in Uganda, you can go and do business in Congo. You don't need certain licenses and all that kind of stuff. It's as if you're native of that particular time, with that particular country. So you're going to see a lot of that. But how are disputes going to be resolved?
Yes.
In your case, with the question which you have asked me, you've said, how is the arbitration process going to run? Usually before people or two entities get into arbitration, they must have an arbitration agreement.
Yes.
And in that arbitration agreement or that arbitration clause, it must say what language they're going to use, what is going to be the seat of arbitration, like in case of the disputes take place, they've got to agree on, are we going to resolve our disputes in Uganda? Is it going to be in China?
Or a neutral country?
All a different country. Most countries, and you'll be surprised that even though, because Uganda will want its disputes to be resolved there if it's a company in Uganda, and the one in China will say, I want it. So usually they choose a neutral country. UK has been known to be very, very effective in dealing in international commercial disputes. Here in the UK, we deal with cases which have no connections at all with the UK, but they choose the English law because of the reputation and how long and the effective of the commercial courts here in the UK, no corruption and all that, and the timeline, everybody knows what is going to be expected, and the parties can decide and say, we want to use the English law to govern our contract, even though they've got no dealings in that country. So during the arbitration agreement, people decide, or the parties will decide what law to use. What is the seat of arbitration? When I say a seat, is where is it going to take place, and what is going to be the applicable law on the contract. Okay, is it going to be the Ugandan law, or is it going to be the Chinese law, or is it going to be the UK law? Yeah. Okay. So they can also choose and say what language. Like you've said, we live in the world everybody has got their own language. So is it going to be in Chinese? Or is it going to be in Russian? Is it going to be... So most people might say, well, although we are all having different languages, we will want our proceedings to be conducted in English. So they agree on all these aspects and these clauses. And this is why the lawyers who are drafting the agreement have got to make sure that they understand that all these things have been talked about. You don't want your client later on to come up and say, have arguments about the language, about how are they going to be paid and all that kind of stuff. You have to kind of like make it tight. So so parties choose before. However, that is in an ideal world. We all know that things don't run according to the way you want them to run. And sometimes they don't do that. And that is why usually when they have not chosen the seat of arbitration or the language, usually this is where institutions like, when they get to the arbitrators, or institutions like CADA, they can assist them in choosing what is the applicable one. Or sometimes if they even don't agree to that, they can go to the court for that specific issue, that we have got an arbitration agreement and we are trying to see this, and then the judge will make a decision on that particular issue, that the relevant law applicable to the agreement is going to be Uganda law or Chinese law or this particular law.
Okay.
So that is how the process is sort of like, usually the process in a nutshell, the process is party-led. It is party-led. Parties decide. Parties have got a lot of autonomy. They decide how many judges or arbitrators
who are going to sit.
Yeah. How many parties have got a lot of power in arbitration. Unlike in the traditional courts, once your case is filed, you will not decide who the judge is going to hear the case. They might keep on changing them. You have no autonomy. And in arbitration, especially in commercial arbitration, it's about a business. Business people want to be in control of how things are going to run. They don't want cases which don't finish. They're losing money. So that's why you see in a lot of commercial cases, parties go for arbitration. because they know they will choose the parties, they will choose the arbitrators, they will decide how long it's going to take. And in case, even for the international cases, once you get, like, for instance, you are arguing against a case, or maybe the other party is from England or is from America, and you've got a judgment. How do you enforce your judgment? Because their properties are not in Uganda, they're in the US. How are you going to reach them? But the beauty of having an international arbitrational award, if it has been got through arbitration, is that it is enforceable, because using the UN Convention 1958, there is an enforceability of the international awards. So even if it is the Uganda arbitrator who has made it in Uganda, it would be as good as it has been made in the US. So all you have to go is with your judgment, make an application over there and say, I want these properties.
And
so
actually,
it's absolutely easy. As long as that particular country is a signatory of the UN Convention of 1958, which most of them are anyway. Yes.
It's very interesting how arbitration and international law come into play. They are kind of intertwined, because, like, I might also add on for the viewers, is that whenever you see international law and domestic law, international law usually takes precedent, and most domestic laws emanated from UN conventions. And convention is something that many countries came together and they decided that most countries will run by this kind of law. A convention usually addresses a problem. For example, we have the United Nations Convention for Human Rights, United Nations Conventions for maybe oil and gas, something. We have many conventions. And now that you've mentioned that you can go to one of the headquarters with your arbitratory award, and you maybe make an application, maybe to get property, maybe from another country. You can see that once you have arbitration, and for people who want to become experts in arbitration and mediation, you may also have to take your career further and to deal internationally with different countries. I think that's what I just wanted to add that.
Yes, it's a very good point which you have added, a very good point which you've added on. Most of our, like you said, most of our laws are borrowed from the international community. But to make it probably very clear is that they could, when we get them, the Uganda government or the parliament has got to ratify them into our law. You can and then make them enforceable. If ratifying, I will give you two examples. For instance, the UN Convention 1958, the one which does with the foreign awards or arbitral awards, it has been ratified. Ratified means that the Uganda legislature accepts it and recognize it, and it is enforced. They take it as if it is law which is made in Uganda. It has been ratified. So it is applicable, it is international, but it's applicable as if it was made by our parliament here, 100%. Now, there is law which hasn't, it's still, we have signed it, we're signatory to it as Uganda, but we haven't ratified it. An example I'll give, so that therefore it means you can't enforce it in Uganda. And an example I can give you is the Singapore Mediation Convention of Settlement. So there is in 2019. It was made in 2019. It's a UN convention about settling mediation awards, between states. Like, for instance, if the mediator has made an award in Singapore and it is through mediation, can it be enforced in Uganda? For instance. Now, Uganda is a signatory to this convention. However, Uganda has not ratified it into our laws in Uganda. So you can't enforce it yet until Uganda ratifies it in parliament and it becomes part of our act. as it did with the UN Convention. So that is the difference. So as much as it will consider it, but you can't enforce it yet. So that's the two things which people need to look at. Yes, like for instance,
difference between being a signatory and ratifying.
Ratifying it, exactly. Ratifying it means you have put it into your legislation and you acknowledge it. So as we did with the UN Convention in 1958 of the foreign awards, which means, for instance, if an award is made against, I'm giving an example, Ham Enterprise, and Ham dealt with, I'm giving an example, it has dealt with an American company, and Ham doesn't have properties in America, but it has properties in Uganda. If they went through arbitration and Ham, an award was made against Ham Enterprises, that American company will come to Uganda and seek possessions of Ham Properties Enterprises. So the Ugandan courts will not be saying, oh, why are you doing this and all that? No, it is enforceable, even though it was made in America.
Oh, that's interesting. And now I think we've dwelled so much on arbitration. Maybe we should now go to mediation, and we also give viewers an oversight, a holistic view of both of these things. So maybe you could first start with mediation. What is mediation, and thereafter maybe take us through the process generally?
Mediation. I personally like mediation. The reason why I like mediation is because it is cheap. It's less formal. It is.
I thought you would go for the more expensive thing.
You would. I mean, as a if I'm talking from the client point of perspective, and mediation can happen across the borders, because these are things which even our grandfathers or chiefs have been doing. There is mediation on that sort of level. Family have got a conflict or custody issues and everything, then you get an elder and it comes to mediate and to come and mediate and resolve things, and everybody's happy and they go happy and thereafter. That's mediation. And mediation has helped in terms of resolving. First of all, it's faster, it is cheaper, there is confidentiality. By the way, similar to arbitration has got confidentiality, but even in mediation there is confidentiality. It resolves a case which would have gone on long and longer in court. Mediation,
it's resolved easily.
It is resolved and people can go on. So usually mediation is absolutely very good, especially if it's done in a professional way, in my view. Yes. You don't want a mediator. Who is a mediator? Mediator is not. They have to understand they're not judges. They're not arbitrators. They are not the ones who make the decisions. It is they help people to make the parties to make the decisions themselves to resolve their disputes. They don't take sides. They're like umpires. They don't take sides. And so as long as somebody understands the mediators are not judges, they don't make decisions. Mediators are not arbitrators. They don't make decisions. It's the parties to make the decisions, but they help people to come through that. So the mediation process in Uganda, we do have the mediation rules, and I think the mediation rules 2013.
I've come across
very
them
clear in under section, I think section 4. It's very clear that before under the civil courts, they're making it in fact compulsory. You file a case in civil court, the judge, the courts will make sure they will order you to go for mediation before the case can proceed. I think Uganda has.
If I may just stop you on that, I was under a certain judge when I was doing my internship, and whenever she would be conducting her court, she would always ask the two parties, the plaintiff and the defendant, that did you guys really resolve it in mediation? And how did you resolve it? Has mediation really failed? Because he or she, being the judge, can look at the facts and say, but this thing can easily be resolved with mediation, because the Ugandan law has put a lot of emphasis on arbitration and mediation. In fact, alternative dispute resolution generally. because they want to avoid you wasting court's time. I don't know.
No, you've said it. You absolutely said it, because people don't want. You have to understand that people go for mediation because they want, or people go to resolve a dispute. Look at it from the client's perspective. They go for resolving a dispute because they want it to be easy and can continue with their businesses. They don't want a case to keep on dragging and dragging and dragging, and they don't want case delays. And I think you've heard how many cases we have in courts at the moment, which are so much delays. Cases are delaying. There is so much backlog.
Is too much.
It's just too much. And in a situation whereby we have the lockdown at the moment, nothing is taking place apart from emergency cases. Already we had so much backlog. So for a businessman who has got a case in court, he's losing millions and millions and millions. There's so much money which is being lost because cases are not being dealt with. Whereas when parties decide and say, you know what, let's go to the mediators. At the moment, we have only not even 400 judges, court officers in the whole country, in Uganda. Can you imagine how many cases we have? There are over 100,000 cases, 150 cases in the Ugandan court. So how many of them can resolve these cases? They're just going to be backlogged so many times. So you're finding out that people are just seated, the businesses are not moving, everything is just at a standstill because cases are not being resolved. Now, if you parties have decided to go through mediation, you might settle in about 30 minutes. And that's why the Uganda law is very clear. It's compulsory. They've made it 2013 mediation rules are clear. Go for mediation, sort yourself out. And then afterwards, you have got to come back to court. Why did you not resolve? And the mediator might not even actually be able to assist you to resolve everything, but it can resolve 3 issues out of 5. And then you only go with only the 2 ones which hasn't been resolved. So,
but at least the backlog is removed.
Is removed, and the expenses. As lawyers, we need to assist our clients not to spend so much money in courts. And I understand some lawyers are saying, if people go for mediation, then they lose out on work. Lawyers, our jobs is not only to go to court. You do negotiations, you do drafting, you do advice. You all of these are things which can be done by lawyers. So there is no fear that if I'm not doing my lawyering job, I'm not going to work. And I know so many lawyers who act at the same time as mediators or arbitration practitioners. Me, myself, I'm doing it. Sometimes I am a mediator. I do mediation work, and sometimes I am doing arbitration practitioning work, and sometimes I'm a lawyer. So the skills of a lawyer, you can really pan them around and you do everything. So more jobs for you. In addition to that, mediation, you don't only have to do even cases which are in Uganda. I have some cases which are in DRC. I have some cases which are in Kenya. So you are like international. Because people in Kenya might be saying, we want somebody neutral. Who is a trained mediator? They go on the list of, like the African Arbitration Association, or like, the Chartered Institute of Arbitrators and Mediators, like one which I'm a member here in the UK, for instance. And they choose your name. They want you to be their mediator. You have no connection to their land. They don't know you. You're neutral. That's what they want, and they will pay you. So you're in Uganda, you're earning dollars, you're earning shillings, you're earning Japanese yen because you're a mediator. You as a lawyer, you've absolutely extended your parameter. This is a career I really want many people to join, because it opens up your boundaries of earning.
By the way, just to give people more hope and support, because many people have been wanting to join careers in arbitration and mediation. So maybe you could give them a word or two, tell them about the benefits of arbitration and also some few disadvantages as we wrap up.
And as we wrap up, personally, I would say join our organization. I'm the CEO and founder of the Arbitration and Mediation Society of Uganda. Join our society so that we can, yes, which can assist you. You can email me at Frances at arbmedsociety.org. Frances is FRANCES at arbmedsociety.org. That is my email address, and whereby
people easily find you. I'm going to put your email in the description of the video.
Thank you. So we could, because the way you do, if you want to start your career, start working with people who actually are in that profession. Because what we do in our society, which we call AMSU, is we do training for mediators and arbitrators. And at the moment, due to the pandemic, our trainings are online. So for instance, for a qualified mediator, somebody to start practicing, at least you must do a minimum of 40 hours of training of mediation work, which we do provide. We do mentoring services. If you're a member of our association, you are just new, you don't know how to deal with it, we can mentor you to become a mediator or an arbitration practitioner. That is another service which you get as when you are a member of our association. We do mediation itself. So for clients who want to do mediation, they can actually contact us and we mediate for them. We do arbitration itself. We're arbitration practitioners. You have a case which has gone wrong and you've got an arbitration agreement into it, contact us and we can act for you. So that is something which we do. And for young professionals or lawyers or even non-lawyers, come join. This is a career which opens up boundaries. At the moment, now we are in a lockdown. But believe you me, our members who are mediators or arbitration practitioners, they're still working because we can do it online, So it is open as we are speaking on Zoom. It's confidential. Everything is going on. Whereas until everything settles, for us, we haven't stopped. So I would say join the profession. Lawyers do not only say, I have got to go to court. I've got, open. You see these new opportunities which have come up.
Think outside the box.
Think outside the box. Now with the Africa Free Trade Agreement, which Uganda has signed, which East Africa has signed, everybody's excited about it, whereby we're going to start dealing with cases in Uganda, Kenya, Tanzania, Nigeria, and all that kind of stuff. They have already made it very clear the way of resolving disputes is going to be by way of arbitration and their dispute resolution court. If there is anything which has gone wrong, it's not going to go to court. So any agreements or money which is going to come up for you, if in fact they are going to be giving, sort of like trying to boost businesses, money is going to come out. And if you're an agriculturist and you want to sell, maybe you want to do maize and you want to trade it with the Kenya, you want to trade it with Nigeria. It's between African states, the way you see the EU work. They first of all, they will fund you to do that. So there is money opportunity for that. But if you have a problem with that company, which is in Nigeria or which is in Gambia, the way of resolving disputes is going to be by way of arbitration. Wow. Now, if you as a lawyer, you're only thinking about litigation going to the Uganda High Court. These are opportunities. Other countries are going to take them up. Where does it leave you? So I'm saying to people, please join. Let us mentor you, get skilled, be international, open up your borders. Uganda is no longer closed anymore. The world is open to everybody.
It's a global village.
It's a global village. So if you stay in your cocoon, that's where you're going to stay. Other people are just going, and many, especially many lawyers, many clients at the moment want people with an international experience. Oh, can you deal with a case in Kenya? Or can you deal with this one, which is in Gambia? I am trying to build up some properties in Rwanda. Are you able to liaise? They want people who have got that. So you can't cut out arbitration. And exactly. So these are opportunities.
Personally, personally, I'm going to sign up because I've been really inspired by you.
I'm
really
grateful. You're welcome, Terry. You're welcome. And your colleague who referred you is a member, and
Kato is a member.
Yeah, he is. He will testify about, all the advantages of this association. So I'm not doing this just to market it, but look at the opportunities. Read for yourself. Yes, read the bigger picture, because at the moment you find out that in Uganda we don't have many arbitration practitioners, and that kills me, and yet we are opening up for these international investors who all of them 99% read their agreements, even those ones of oil and gas. They'll say to you that they want arbitration. People keep on complaining, why are the cases being handled in the UK? It's because all these agreements they signed, they've got to be settled by way of arbitration, and the seat is UK, is England.
Yes. Wow.
Now, then you yourself are like, they are giving these white people jobs and all that kind of stuff. You're not an expert in arbitration law. You're not an expert. You've closed up yourself that the government has got no choice but to get these English lawyers to come and argue your case. So where are the Ugandans? We've closed up. Please open up. It's not a complex area. If you've done law in Uganda, I can assure you, you will be able to do the law in UK, common law. It is very similar, 85% similar. I've done both, and even if the things are a bit different, you will adjust very quickly, very, very quickly. And that's why in the Ugandan law, they made it very clear that if you qualify as a lawyer, for instance, in the UK, there are just a few trainings which you can do. And as long as you've been practicing for over 5 years in the UK, you've got good recommendations and all that, you can join the bar, the Ugandan bar. The law is there. Do you think they were not thinking by the time they put that legislation? It's because they know our laws are so similar. So you who are trained in Uganda, you're good enough to act in any country which does common law, in Kenya or wherever, because we are very similar. So please don't close up, open up for these opportunities, and the sky is the limit. Personally, I'm enjoying my career. I really like it. Mediation, arbitration, lawyering.
And I can see you're passionate about it.
I'm very passionate about it, and I would like to get many of us join. In the whole country, Uganda, we're not even 4,000 lawyers. In Uganda, the Uganda Law Society, those who are on the roll, we are about 3,500. And a country of 45 million, We are even few lawyers in Uganda.
But there are actually a few lawyers.
Exactly. So those few lawyers, I would like us to get even mediators. I would like us to get arbitration practitioners, And lawyers have got an advantage because of our training, analytical, drafting, interviewing, all this, being eloquent in your speeches and everything. We put our case there, so we are like a step ahead. Not that those ones have known that exactly. So why not take up the opportunity?
Yeah, personally, you've inspired me to really dwell so much into arbitration and mediation. I already have one certificate, so I want to get more and more certificates. I want to explore this avenue of arbitration and mediation.
Thank you. And you're welcome. Just to put in my details and let people email us and join AMSU. It's a new organization, and the sky is the limit. It's global. Once you join, so that will help you attend as many conferences as possible. There's so much which is going on. You'll get to know what is happening in an international world. But to tell you, at the moment on the international world is business. People are tired of being poor. People want. They're
tired of litigation.
They're tired of litigation. Litigation doesn't end. You can have a case in court for 10 years. Which business person wants to deal with that? They want quick things and resolve their things.
Especially Ugandan businessmen, they want
quick things. So when it comes to if you're a lawyer, you're drafting a contract, they want to go for arbitration, or they want to go for mediation. And that's why our laws are saying no. We go back through mediation. It's just that mediation sometimes is not done properly, and it fails. But for us, our mediators are trained, that's why our cases are getting resolved as quickly as possible, because we have trained mediators. You don't want a mediator to act like a senga, sort of like, telling you off, instead of like, I'm sorry. You're not supposed to be a judge saying, no, you did wrong, you did. No. It is being...
Just bring two parties together.
Let them come with the solutions and deal with it as a mediator and manage it. Let them have the resolutions. And also, by the way, although I said that mediation might not have an enforceability, as with AMSU, there is a way, because we have lawyers on the team. People, when they come out with a mediation agreement or which they have resolved, we can get our lawyers to draft it into those resolutions or the agreement itself. We can turn it into an agreement, which in case one party doesn't follow it, they can sue it on a breach of a contract. So although the resolution at the moment, just mediation, it's not enforceable, some person, because that is one of the problems which comes up. People are saying, it's not enforceable and all that, but you can change it and make sure that there is that enforceability out of mediation. So the downfall of it is the problem which we're having is the lockdown, obviously. People don't have much money to do the training at the moment which we require, and there is a lack of awareness about mediation and arbitration work. But it's the African promise. We just have to keep on going and going. These are things which can be dealt with. We embrace IT, like what we are doing at the moment, so that, everybody can reach you. At the moment, I'm in the UK, you are in Uganda, we are having a conversation. So we embrace all the technology to make sure that we match up to the world.
I love the fact that you're positive and you're flexible with life. That's the way to go. And initially, this is how I began this channel, Simply Legal. I began it last year during the first lockdown when Corona had just really hit the world so bad. And I thought to myself, how can I actually reach the world with my legal knowledge? And I'm really humbled and honored to host you on my channel, because you have such a big profile and I'm just getting started. But I hope the viewers can learn so much from you, because people are always asking me to bring big personnels onto my channel. So I'm really humbled that you accepted my request to be on my channel.
Thank you very much, Terry, and Simply Legal, and thank you for hosting me.
Okay, so thank you so much, viewers, for listening to me and Madame Frances Ddungu. I'm going to leave her details and credentials in the description. I really hope that you guys will blow up our comment section, be asking us more about arbitration and mediation. For those who want to contact her, I will leave everything in the description, or you can contact me personally. I'll connect you to her, and you will be able to reach her by way of email. I think she prefers that professionally. So we are so happy to have hosted you on this channel. Thank you so much. I think we've exhausted a number of things, and I hope to do a part 2 with you, because there's a lot to capture in terms of arbitration and mediation. This was more of an introductory video, but personally, I've enjoyed the session. You've inspired me, and I've really loved everything that you've given us, all the information. I hope many people have been inspired by this video, and I know at least there's a common saying that a word to the wise is enough. So people are going to contact you. I'm very sure of that. Personally, I'm going to sign up, and the sky is the limit for Ugandan law. And I don't know, any final words you'd want to say to us, Madame Frances?
Thank you so much, Terry, for hosting me. I really usually get inspired by young professionals and upcoming, especially lawyers, because you guys are flexible and are eager to learn and are the future of our country. And I would like to inspire, especially lawyers, really, really lawyers. Honestly, take up this opportunity. Don't think outside the box. Think outside the box. Becoming a lawyer mainly is about resolving disputes, ensuring that the parties can access justice. That is why you went to law school. It's not just to go to court. It is about access to justice. So as a lawyer, the way of people can access justice is using everything possible to resolve their disputes. And that includes arbitration, mediation, expert determination, negotiations, and also to open up their opportunities, see opportunities which are out there, like take advantage of the new opportunities which have come up, like the Africa Free International Trade Agreement, which Uganda now has signed up, and by June they're taking up professionals, deals are being signed up. Think money. I think money, because Africa, our main problems is obviously poverty. Other problems are there, but if we have money and you manage your clients to be able to have a few coins in their pockets, you've resolved the biggest problems which we have. So be financially motivated when you're advising your clients, see the opportunities which can help them to make more money. Even you yourself, better yourself in your career, look good, you know, be able to have a career which can give you motivation even to work the following day, a career which can pay your bills and, you know, and resolve the poverty in your family or whatever it is. And at the same time, be positive, be aspiring, be ambitious, and I will welcome you all at AMSO. Thank you very much.
Okay, I hope to do a part 2 with you. We definitely have to do a part 2 on our mediation and arbitration, because there's a lot to cover in dispute resolution. But as for now, bye, and thank you so much for being hosted on Simply Legal. Thank you so much for our second Zoom guest, and we're hoping to feature you again on the channel, and we'll see you next time. Thank you.